Good morning, everybody. Welcome to the 8th Annual Estate Planning and Community Property Law Journal CLE and Expo. My name is Ashley Snell, and I'm the Editor-in-Chief of Volume 8 this year. The EPJ is the only student-led publication of its kind in the country, publishing articles on estate planning and community property law. Its audience includes attorneys, judges, professors, and students, and many other estate planning professionals. Our journal publishes outstanding student comments and scholarly articles written by wonderful professionals, national and international experts in the fields of estate planning and related topics. Accompanying the printed version of our journal, as many of you know, is the online edition called the Codicil, which can be accessed through our website, which is new this year, epj.us. We are very proud to announce that this week, the Texas Bar Foundation awarded the Outstanding Law Review article to Turney Berry and Paul Lee for their article entitled Retaining, Obtaining, and Sustaining Basis, published in Volume 7, Book 1 of the EPJ. This award marks the second time that the EPJ earned this honor in its 8 years of existence, as Texas Tech Law's very own Professor Brian Camp won the award in 2010. Today, we are pleased to bring you the largest event in our journal's history. As expected, an event of this magnitude involves significant planning and details, and we are fortunate to have our executive symposium editor, Alyssa York, at the front of it all. Alyssa has gone above and beyond to put this together for you all, and additionally to organize the wonderful reception that we had yesterday evening at the Overton that many of you were able to join us at. Please welcome to the stage, Alyssa York.
I just wanted to say thank you so much for all of y'all being here today. This event has been about a year in the making, so I just really appreciate you being willing to be a part of it. And it wouldn't be possible without our wonderful sponsors. So we had a reception last night to thank them, and we're so fortunate that they came out for that. But I did want to remind you guys, we have some exhibitors outside, and 2 of them are actually doing a raffle today. So on your breaks, if you'd like to go over there and say hi to them, we have Happy State Bank. They have a raffle for a poker set. So head on over there and give them your business card, and hopefully you can win that at the end. And then Southwest Bank is having a raffle for a $100 Visa gift card. So you'd be really inclined to go say hi to those folks. And we also have First Financial Trust and Asset Management Company. And they have a table out there, and they would love to talk to you. And we just want to say thank you to all of them for being here, and thank you to you guys for being here, and we'll get started. Thank you.
We are very excited to have the Dean of Texas Tech University School of Law, Dean Darby Dickerson, to provide opening remarks today. Dean Dickerson received her law degree from Vanderbilt University. Prior to becoming dean at Texas Tech, she served as the dean at Stetson University College of Law in Tampa, Florida. She's the author of the ALWD Citation Manual, which is currently in its 4th edition. Additionally, Dean Dickerson is a member of the American Law Institute, an officer and director of Scribes on the Association of American Law Schools Membership Review Committee, and is a co-chair of the AALS section for the Law School Dean. Please join me in welcoming Dean Darby Dickerson.
Good morning, everyone. Welcome to Texas Tech. For those of you who are not normal members of our community, we are so excited about this symposium. I know that there is a wonderful lineup of speakers. I had the pleasure of having dinner with them last night. I am not in the estate planning field, but found the topics fascinating, and I'm going to sit in a little bit today to hear the interesting things that they have to share with us. Some thanks to some people. First, to reiterate what Alyssa said, we want to thank the sponsors. Without you, we could not have this big and successful of a symposium. Second, I would like to thank the EPJ, led by Ashley Snell and Alyssa York, on the symposium for all of your hard work. I know that this does take a year to pull off. You guys are so hardworking and professional. You're such wonderful representatives of the law school. I really appreciate it. To the speakers who have traveled to be with us today, again, we're looking forward to it. We appreciate you sharing your time and expertise with us. And to Professor Jerry Beyer. He is one of our stars here. Texas Tech has an amazing faculty. They are so talented and passionate. Jerry is a star among stars. He is such an expert in this field. He is the moving force behind our journal and the symposium, and we are fortunate to have him here. If you haven't had the opportunity to interact with him, please do. He is a dynamo, and again, such a star in this area. If we can do anything to make your visit here today any more special, please let us know. Feel free to wander through the building and to see parts of campus. Some people are surprised when they come to Lubbock and see such a lovely university and community. We're very proud of it. Without further ado, I'm going to turn it back to Ashley so that we can get on with the main part of the program. Thank you very much.
Thank you, Dean Dickerson. We've brought an outstanding lineup of speakers for today's events, with presentations covering a variety of topics and issues in the fields of estate planning, taxation, community property, and other related topics. So without further ado, let us begin. Our first speaker of the day is Mr. Darren Moore. Mr. Moore is a shareholder with Bourland, Wall, and Wenzel PC in Fort Worth, Texas. After attending Texas A&M University, Mr. Moore received his law degree from Baylor University. His practice focuses on representation of nonprofit organizations and social enterprises, advising clients on a wide range of tax and legal compliance issues. Additionally, Mr. Moore assists in IRS audits, attorney general investigations, and litigation matters on behalf of his exempt organization clients. Mr. Moore is the author of the blog More Thoughts on Nonprofit Law, where he comments on legal issues affecting nonprofits and offers thoughts and advice on various nonprofit legal issues. Mr. Moore is an adjunct professor at Baylor Law School, where he's taught nonprofit organizations since 2001. He has been a guest lecturer at the University of Texas School of Law and SMU Dedman School of Law on nonprofit organization topics. Additionally, he writes and speaks regularly on tax and legal compliance issues. Mr. Moore's presentation today is called Care and Feeding of Private Foundations and Public Charities. Ladies and gentlemen, it's my pleasure to introduce to you Mr. Darren Moore.
This is a long time coming for me, and what I mean by that is I was supposed to be here last year and had a flight mishap coming out of DFW. So they were kind enough to invite me back, and I really do appreciate being invited back. I want to start us off today talking a little bit about the charitable sector, which may not be an area that you particularly focus on or that you work in, but is a significant area within our country. Behind, I believe, retail and manufacturing, the charitable sector is number 3 as far as the workforce. It's a huge sector, and it's something that I think we enjoy in America because we like to help each other. And this is not unique to Americans. I think all people like to help their neighbors, but it is something that has long-standing roots in America. When he came over to America in the 1830s, before writing his book on democracy, Alexis de Tocqueville commented that anywhere you might see government in Europe and government leaders or the nobility leading a cause, in America you saw associations and society. So we have a very deep history with the nonprofit sector, and even today we see people who want to help. They want to help in their communities, in their schools. They may want to help in their world on a broader effort. It's very wealthy people. Maybe they are influenced by family philanthropy, or maybe they've been influenced more recently by the Giving Pledge. And it's also people who are not independently wealthy, but say, I want to make a difference. And we as professionals are in a unique position to come alongside those people who are trying to help others and make sure they stay within the boundaries of the Internal Revenue Code, as well as state regulation. And so I want to talk a little bit about some key issues of the contours of the independent sector, particularly Section 501c3. We're not going to get into governance, which is a critical aspect of this, but we're going to talk about the key issues, some definitions in the Internal Revenue Code, as well as some areas where we may need some particular extra attention. So when we talk about the nonprofit sector as a whole, this bullseye gives us an idea of what it is. Nonprofit organizations are not all tax exempt. All tax exempt organizations are not all charitable organizations. To be a nonprofit organization simply means that you don't distribute profits to shareholders in the form of dividends or otherwise. You can pay compensation, but there's no equity in the nonprofit. There's no ownership of the nonprofit. It's called the non-distribution constraint. Within that sector is a tax-exempt sector, and there are some 30-odd sections of the Internal Revenue Code that talk about tax exemption. So we're familiar with 501c3s. Due to election cycles, we're often familiar with 501c4s, social welfare organizations. But we can go on up the list. In fact, 501c3s are not even the only tax-exempt organization to which you can make deductible contributions. You could actually make a deductible contribution to a cemetery corporation or to a veterans association. But we're going to focus on 501c3s because by and large, that's the biggest part of the tax-exempt sector, and most of us are going to deal with those types of organizations. Within the realm of Section 501c3, we have a couple of types of organizations. These are all 501c3 organizations, so keep that in mind. But within that, we have public charities and private foundations, which is the center of our bullseye. Both of these organizations are 501c3, which means what? It means that no matter whether we're talking about a public charity or a private foundation, they have to be organized exclusively for exempt purposes: charitable, religious, educational, scientific, testing for public safety, etc. And when we say exclusively, we mean primarily because Congress and the IRS interpret things somewhat oddly sometimes when we're looking at the Internal Revenue Code. So the organizational document's going to have to say, this is what we're organized to do, and not give power to do something else. Number two, they have to be operated for that purpose, which means there's a public purpose. Number three, they can't engage in private inurement. That's the giving money to insiders other than as compensation or something like that. That's the non-distribution constraint. Number four, they can't be an action organization. So in years like this year, they can't get involved in political campaigns for or in opposition to a candidate for elected public office. They can't engage in substantial amounts of lobbying. Private foundations actually can't engage in lobbying unless they pay a taxable expenditure, and we'll talk about that. And they can't violate public policy. And that's one that's added by the courts. That's not in the code, but if there's a public policy and they are violating that public policy, then they're not going to be eligible for tax exemption. So that's the starting point. All of these organizations have to meet those requirements. But beyond that, the default organization, when you meet those requirements, is a private foundation. If you tick off those requirements, organized and operated, et cetera, that qualifies you under 501c3 to be a tax-exempt organization, which means effectively you get a double subsidy. Number one, you don't have to pay federal income tax. Number two, when people give to you itemized deductors, they get to deduct that on their personal income tax return. If that's all you've got, then you're going to be classified as something called a private foundation. Private foundations are subject to more restrictive requirements. Because of that, if you can avoid private foundation status, you try to avoid it. The ways that you can avoid it are listed here. You're a traditional public charity, publicly supported, a supporting organization. We're going to go through these definitions in just a bit. So, if you can't qualify as a public charity, by default, you are a private foundation, but again, a private foundation is a 501c3 organization. Now, there's a couple of types of private foundations that I want to highlight today. By and large, the most common type of a private foundation, and the one that most of us create when we have individuals come to us and they either want to make an inter vivos gift or they want to make a testamentary gift to a charitable organization that's going to be privately funded and controlled, they're going to be creating a private foundation. And the most common type is going to be a private non-operating foundation. Private non-operating foundations get their money generally from one or a few sources. So when you have a client come to you and they say, I want to create something to carry on my legacy of charitable giving, and I'll have my business associates run it because I don't have children, or I'll have people in the community, or I'll have my family run it, we're talking about a private non-operating foundation. It can have more than one donor, but typically it's one or a few donors. Take the example of the Bill and Melinda Gates Foundation. They actually went out and got one more very poor person to invest in their private foundation named Warren Buffett. So I don't know if William has money or not, but Warren Buffett. And so you have multiple people, but it's a small number who are investing in that. Now, they don't actively raise funds. You can give money to a private foundation if you're just a member of the community, but they're not out there raising funds because they're getting their funds from one or a few sources. We know they're required to distribute about 5%. We're going to get into that. And their income tax deductions for the donors are a little bit different, and here's what I mean by that. Gifts of cash and non-appreciated property, when given to private foundations, are not as valuable to the donor who's bumping up against their adjusted gross income limit as gifts of cash and non-appreciated property are to a donor giving to a public charity. Likewise, gifts of appreciated property are not as valuable. So what I mean is, if you've got an adjusted gross income of $100,000 and you are going to give $40,000 to a private foundation, you're only going to get to deduct $30,000, and you've got to carry the extra $10,000 forward. There's a 5-year carry forward. But if you have $1 million and you're giving something above, you may not meet that 5-year carry forward, and you may lose some of that deduction. So it's more preferable to go to a public charity, but certainly a donor that's looking to create a private foundation is going to need to think about, how do I fund this, perhaps in tranches, so that I don't lose part of my deduction. Gifts of appreciated property are a little bit trickier. If it's a gift of qualified stock, you get to write off the fair market value. But if it's not a gift of qualified stock, you can only write off the basis. Example of this, it came up a couple of years ago. We had a donor, and he wanted to give a wine collection to his private foundation. Well, the wine had appreciated. He can only get basis. He had held the wine a long time. The basis was relatively low, so that wasn't something that was very valuable to him. The one exception to when you have to only take basis is if you're giving something to the private foundation that the private foundation is going to be able to use in furtherance of its exempt purpose. So let's assume the private foundation operates a museum as a private non-operating foundation, and you're giving a painting that they're going to hang on the wall. You would be able to take fair market value. Okay, so I want to talk now a little bit about what's called the prohibited transaction rules for private foundations. This is really where the rubber meets the road when advising private foundation clients. This first one is actually not a prohibited transaction. Interestingly, it's at 4940 of the code, and 4941 through 4945 are all prohibited transactions where you pay an excise tax if you violate it. This is an excise tax that is always going to apply. They call it the audit tax because in 1969, when Congress came up with the idea of private foundations, they said, if we're going to have private foundations and we're going to have all these rules, we're going to need to hire extra people to go audit these things, and we need the private foundations to give us money to do that. So they implemented this rule. Well, they've made a lot more money than they've paid to agents as reviewers. It's certainly a money source for the government. It's effectively an income tax on a private foundation. So when we talk about tax-exempt organizations, we're fudging just a little bit because there is a tax applicable to private foundations that's not applicable to public charities, and that is the 4940 tax on net investment income, or the audit tax. The tax is 2% of your net investment income. So your gross income plus capital gains minus capital losses less ordinary and necessary expenses. To generate that income, you pay 2% of that every year to the IRS. That can be reduced to 1% under certain circumstances, which is essentially, so long as you've met your required payout, there's an averaging, but so long as you've met that 5% required payout, if you take that extra 1% of net investment income and pay it out to charity, then you can pay the government only 1%. So there is a way to reduce it, but otherwise, this is not a tax you get out of because this is not a bad actor tax. This is simply an income tax on private foundations. The most common, in my experience, bad actor tax is a tax on self-dealing. Self-dealing is defined in the code specifically as certain actions between a private foundation and a disqualified person, and these can either be direct or indirect. Now let me go on to define disqualified person, and then we'll come back to the examples. Disqualified persons, if you don't work in this sector, is kind of a weird word, but it effectively means persons who are disqualified from having certain transactions with the private foundation. Number one are foundation managers, people who are officers, directors, trustees. Number two are individuals who are substantial contributors. If an individual has given more than 2% of the total contributions to the foundation since inception, and that amount is more than $5,000, which it almost always is, then that individual is a substantial contributor. Now, what if a business gives more than 2% since inception and that amount is more than $5,000? Well, then that business is a substantial contributor. What about the people who own that business? Well, individuals who own more than 20% of a substantial contributor, those individuals are considered disqualified persons. That's number three. Family members of any of those individuals are also considered disqualified persons. And that is spouses, parents, grandparents, children, grandchildren, oddly enough, not siblings. Siblings don't count for disqualified person status for private foundations. And then entities that are more than 35% owned by one of these disqualified persons are also disqualified persons. So it's there's this broad section. Let me stop here and say, you did receive a paper. The paper covers pretty much everything that I'm saying, and I'm happy for you to get the slides. You can email me. My email address is on the paper, or I usually will have this up on my morenonprofitlaw.com or whatever it is. It's also on the paper. So you'll get the slides. Don't feel like you have to write everything down as quickly as you see it. But these are all disqualified persons, and this can become a little bit tricky because assume, for instance, that you have a person who is a substantial contributor, and that person owns 80% of a business. And he decides, in addition to providing more than 2% personally, I'm going to provide it through my business. The 20% owner, who doesn't have anything to do with the foundation, also becomes a disqualified person, because that's what number 3 says. Now let's assume that that 20% owner has a daughter, and she gets married, and her husband, who is the son-in-law of the minority owner of a substantial contributor, owns a lawn service. And let's assume the foundation, they've got a different last name. Now let's assume the foundation hires that lawn service. Guess what? We've just engaged in an act of self-dealing. So you really have to watch who your disqualified persons are. So what are the acts of self-dealing? Sell or exchange or leasing of property. So we can't sell property or lease property between foundation and disqualified person. Often comes up, board member has an office and says, I'm not using this office, the foundation needs an office. Can I lease it to the foundation for a sweetheart deal? The answer is only if you want to pay an excise tax on it, and then potentially a higher excise tax, and then potentially lose tax-exempt status. It is a non-starter. You can't charge the foundation money. It's got to be free to the foundation. If you give it to the foundation for free, you lease it at no cost, you can do that. But sales, exchanges, or leasing of property is a violation of the self-dealing rule. Lending of money or extension of credit. Certainly the foundation can't lend money to the disqualified person, but in fact a disqualified person cannot lend money to a private foundation, even at a low interest rate or below market interest rate, unless it is without interest. And if you lend it to the private foundation without interest, the private foundation has to use those funds for their exempt purpose. So you can't get into a situation where disqualified person lends money to a private foundation so that the private foundation can go out and engage in some sort of unrelated business generating income. It's got to be used for part of their exempt purpose. Furnishing of goods, services, facilities. The exception here is if a private foundation, part of the private foundation's exempt purpose is to provide goods, services, or facilities to the general public, then the disqualified person can get those goods, services, or facilities on the same basis that is provided to the general public. For example, you've got a museum. The museum's a private operating foundation, which we'll define, and the museum has an admission fee. The disqualified person is allowed to pay the admission fee and come into the museum. So you can do that. Likewise, if the disqualified person wants to give some goods, services, or facilities to the private foundation, it's got to be free. Now, free is an interesting word because free usually means without charge of any kind. One thing that has been helpful in our practice is that with respect to artwork, the individual can give it to the private foundation, let the private foundation hold it, and the private foundation can pay the upkeep on the artwork, which is a nice thing if the individuals don't want the art in their house but want to maintain the art. Now, payment of compensation is a self-dealing transaction. This is the biggest exception to self-dealing, is the payment of reasonable compensation for services that are necessary to the private foundation, where those services constitute what the regulations call, quote, personal services. So what does that mean? That means if a person is serving as a foundation manager, let's say they're serving as the investment advisor, or they're serving as the president, or they're serving as general counsel, or they're serving as a CPA, all of those types of things are personal services, and the regulations expand on that. What we don't really know is what are not personal services, with one exception. There's a case called the Madden case. And in the Madden case, the question was, are janitorial services personal services? And the answer was no, analogizing to janitorial services versus legal services. While many people would say those are about the same, you're just cleaning up a mess, that wasn't the result in that Madden case. The result was those are not personal services. So I had an example a few years ago where the foundation wanted to pay a disqualified person. The foundation trustee, executive director, wanted to pay his son to write a children's book. Well, the foundation's purpose was grant making for religious causes. Writing a children's book was outside of the foundation's purpose, and they said, well, but he's going to give us a royalty off the children's book. That's if it gets published, et cetera, et cetera. So setting aside whether it is a prudent investment, the issue was we would be paying money to a disqualified person, the son of a trustee, and the disqualified person would be providing services that are not reasonable and necessary and not personal services to the private foundation. The other big exception that most of you probably know about is the estate administration exception. The estate administration exception says, notwithstanding this list and the rest of the comprehensive list in section 4941, you can engage in self-dealing as part of the administration of an estate or irrevocable trust. What this looks like is the instrument, the will or the trust document, has to give the executor or trustee the power to sell. It has to be done under court supervision. Even if you've got an independent administration, it's got to be done under court supervision. You have to make sure that fair market value is paid and that what the foundation gets is at least as liquid as what it's giving up. So we've got a case in our shop right now where the situation is we had a very wealthy donor. He died, left the residue of his estate to his foundation. The residue of his estate included multiple houses, a number, cars, everything else. Well, one of the houses is of interest to one of the family members. And so we've got to do what? We've got to look at the will, in this case a revocable trust, and determine is there a power to sell? Yes. Okay, it needs to be under court supervision. We need to get a fair market value, so we have to get an appraisal. And then we need to make sure that the person's able to pay something as liquid as what the foundation's giving up, which makes sense because the foundation's giving up a house. But we have to file an application with the court and go through that process. And it doesn't matter what the asset is. So in that same case, we have a little $2,500 golf cart that's used to tool around the neighborhood, and one of his siblings wants to buy that golf cart. We still have to go through the same process. We've got to go to court, we've got to seek approval, we have to figure out who can appraise a golf cart, and go through that process. Another example of when this comes up quite often, mom gives a loan, interest-bearing, interest-free, doesn't matter, demand loan, installment loan, doesn't matter. Mom gives a loan to son. Mom dies, leaving the residue of her estate to foundation. Now foundation is the owner of a note where son, disqualified person, is the payor on the note. That's self-dealing. Not only is it self-dealing in the year that it happens, when the year that the foundation takes ownership of the note, it's self-dealing, it's a new act of self-dealing for each subsequent year while that note is outstanding. What can we do about that? Well, within the number one, you can refinance it or pay it off, but within the context of the estate administration exception, we have some flexibility to renegotiate that under court supervision to a fair market value so that the foundation can go on being the owner of the note if the child is not in a position to pay it off or to refinance it. So self-dealing is a huge issue that we have to look at. Second prohibited transaction. We have to do some work to make this a prohibited transaction. It's kind of a mandatory deal. You got to pay out 5%, but to make it prohibited, we say you can't fail to pay out 5%. So you can't fail to make your minimum distribution requirement. The minimum distribution requirement is roughly 5%. That's what most people will think of when they say, what does a foundation have to give every year? 5%. 5% of what? 5% of its asset base, which includes assets not used in furtherance of the foundation's exempt purpose. So what's used in furtherance of your exempt purpose? Your office building is used in furtherance of your exempt purpose. Your copy machine is used in furtherance of your exempt purpose. So what makes up your asset base? Your investment assets, your endowment, a large ranch that you may own that you don't use as part of your exempt purposes. All of those things make up your asset base. You look at that asset base, oil and gas, other type of minerals, you value those, and there are different valuation techniques depending upon what you're looking at in different time periods within which you value it. You value those, you get the full value, you pay 5% of that. There's some exceptions and set-asides. You get to deduct the amount you pay the net investment income tax, but it's roughly 5% of your investment assets every year has to go out. And how does it have to go out? It has to go out in what's called qualifying distributions. Now, the common thought is that qualifying distributions means we need to pay it to a public charity, but that's more restrictive than the actual rule. That may be what your governing documents say, so you do have to look at your governing documents. If the governing documents limit you to paying to public charities, then you have to follow that. But in general, qualifying distributions will include the overhead for running the foundation, except for the overhead for your investment purposes. It'll include grants to public charities. It'll include grants to non-charities for charitable purposes. So what's an example of that? Giving to your local Chamber of Commerce for an educational program. Chamber of Commerce is a 501c6, trade and professional association, or you give to your local bar association for an educational conference as a private foundation. That's still going to be a qualifying distribution. You give to a for-profit organization, but you do it for a charitable purpose. I had a client who gave a grant to a for-profit medical practice that was in a rural area to allow them to buy equipment for prostate screenings because there was no one around that had that type of equipment. Part of the agreement was that they would provide those services for free to the community. So that is a qualifying distribution. Now, if you're not giving to a public charity, then for it to be, it'll always be a qualifying distribution, but for you to avoid taxable expenditure status, which I'll talk about in a few moments, you have to go a little extra, and that's what I'm talking about here when I say expenditure responsibility, which I'll define. Costs of direct charitable activities. You're a private foundation, very interested in Alzheimer's research, and so you convene a conference of researchers or other foundations. All the costs related to that are going to be qualifying distributions. There's a tornado that comes through town, and you provide blankets. That's all going to be a qualifying distribution. So it's quite broad what you can do to be a qualifying distribution. Instead of looking at who the recipient is that you have to pay your 5% out to, look at why you're paying the 5% out. If it's for charitable, religious, educational, scientific, etc. purposes, then it's going to count as a qualifying distribution. Third prohibited transaction, self-dealing, 5% payout. Third is excess business holdings. Congress has imposed a limit on the amount of business interests that a private foundation can hold. The reason for this is that they want private foundations to keep their eye on the ball and say our purpose is our exempt purpose, not running a business. So to do that, Congress has said you can't own more than 20% of the business interests of an active trader business unless that business is functionally related. So let's assume a private foundation is providing work for the disabled. And they make grants for the disabled, but they also have a job training center. And they run that job training center as a business. They can own that because it's functionally related to their exempt purpose. But otherwise, you can only own 20%. And it's not just the foundation who can own up to 20%. It's the foundation plus its disqualified persons. Well, why would that matter? What they're saying is you can't, mom and pop can't take their business and say, we're going to give 20% of this or 30% of this or even 10% of this over to the private foundation, and we're going to keep the rest so that we get a write-off, a charitable deduction of the 10, 20, 30% we gave away, but we still control the whole thing. Congress doesn't allow that to happen. You add up the amount owned by the disqualified person and the private foundation. Now, if there's someone else in control that's not a disqualified person, then you can go up to 35%. The only exception here is if the foundation owns 2% or less, then it doesn't matter what the disqualified person's own. So if someone wanted to put 2% over into a foundation and keep the other 98%, Congress will allow that. But if you get to 3%, you don't get to say, well, 2% was okay. You're taxed on the entire 3%. And each of these taxes, self-dealing, the taxes on the self-dealer can't be abated. Failure to pay out your minimum distribution requirement, there's a tax on the foundation of the under payout. And on excess business holdings, you're taxed on the amount of the excess business holding. So you would be taxed on the entire 3% if the other 97% were held by disqualified persons. You cannot go out and buy an excess business holding. So if a foundation decided that's a great opportunity, this person wants to sell the business and we can run it, it's not functionally related but we'll make a lot of money, that's an automatic excise tax penalty. However, what typically happens is the foundation receives the business holdings by gift or as part of the residue of an estate. And in those situations, the code gives us 5 years to dispose of that excess business holding. And if there's some reason you need more than that, you can apply for an additional 5 years to dispose of that excess business holdings. Who can you dispose of it to? Anyone who's not a disqualified person. If the person's a disqualified person, it would be self-dealing to sell it to them. Unless what? Unless you do it while an estate is open and it's during the administration of an estate subject to court approval. So these rules are going to have to work together. There are other ways to deal with excess business holdings. One that we've used in our planning is to recap the organization, create voting and non-voting units, move the equity largely to the non-voting units because a foundation can own any amount of non-voting units. That's a way to shift the equity over to the foundation while leaving the disqualified person in control of the organization. Jeopardizing investments is our fourth type of prohibited transaction for private foundations. This is just like UP and UPMIFA. They're all based on modern portfolio theory. So you have to be prudent. You look at diversification of the portfolio. You look at the portfolio as a whole, not on an investment by investment basis. And you examine, looking at the risks associated, looking at your portfolio, will this investment jeopardize the short-term or long-term interests of our foundation? Will it cause us to go out of business? Will it lock up all of our assets? Let's take a hedge fund, for example. A hedge fund may be a great investment, but if there are unlimited capital calls or if your assets are locked up for a significant amount of time and you're not going to be able to make your 5% payout, that might not be such a great investment. So you're going to look at all of those issues. There's no per se violations in the code, though the regulations give us some examples of violations. Keep in mind, these regulations were written in the 70s. So they say things like trading on margin, selling short, having working interest in oil and gas wells, that those are things that require extra scrutiny. It doesn't mean you can't do it. It means you need to analyze it in the context of your overall portfolio. So I had a lawyer call me last week and said, the foundation is looking at investing in these working interests, these working oil and gas interests, along with the disqualified person. It seems like a good deal. What issues should we think about? And what I said to him was, well, you need to think about jeopardizing investments, and here's the issues we're going to look at. And he said, okay, I'm concerned because the foundation already owns other working interests in oil and gas wells that they received by the decedent at his death. Well, that's not going to be a jeopardizing investment. If you receive it by gift, it's not a jeopardizing investment for you to hold that investment. And then our last prohibited transaction is a taxable expenditure. Expenditures that are not in furtherance of your exempt purpose. A great example is you engage in political activity. You go out and you support a candidate for elected public office, either at the local level, state level, national level, whatever the case may be. Even internationally, you support a candidate for elected public office, that's a taxable expenditure. You engage in excess lobbying. There's a section of the code that allows you to have a bright line, or you can follow a substantiality test for the amount of lobbying if you don't want to do 501H. If you engage in excess lobbying, it's a taxable expenditure. If you give to a for-profit, not for charitable purposes, number one, it's not a qualifying distribution. Number two, it's a taxable expenditure. You give to a for-profit for charitable purposes, like my example of the prostate screening grant, it is a qualifying distribution, but it's also going to be a taxable expenditure unless you exercise something called expenditure responsibility, which is due diligence. Pre-written grant agreement, you say this is what we're going to use it for, this is what we're doing. You investigate any diversions of the assets, they report to you, you report to the IRS. If you're talking about grants to individuals, you have to get IRS approval of scholarship procedures before making those grants. If you're talking about disaster relief, you do not. So those are our prohibited transactions for private foundations. Now, what is a private operating foundation? It's a private foundation, but instead of giving away money, it carries on as direct charitable activities. A museum is a great example of this. So the money comes from one or a few sources. However, they're operating a program. They're operating a ranch for troubled youth. They're operating a museum, etc. Now, you get the more liberal public charity deductibility, but they have to meet an income test and one of three other tests. The income test means they have to distribute substantially all, 85% or more, of their adjusted net income or their minimum investment return, so 4.25%. They can't distribute it in grants. They have to spend it on their programs. This is in replacement of the 5% requirement. But in addition to that, they have to meet an assets test, which says most of our assets, 65% or more, are held for our exempt function, operating the museum, or an endowment test. This is an either-or, direct distributions of at least 2/3 of your endowment, 3 1/3 of its endowment. And then there's a support test. I'm not going to cover this. It's very rarely in play. They're subject to all the same rules, except they're not subject to the tax on undistributed income. Why? Because that's not something they have to do. But if they don't satisfy the income test and one of the three other tests, They don't lose their 501c3 status. They become a private, non-operating foundation. Now, I've got a few minutes left, and I kind of want to run through public charities. This is not quite as significant for most planners because most of us are going to be working with private foundations, but it's helpful to understand what is a public charity and why are they a little bit different. We've got 4 types of public charities. We've got institutional or traditional public charities, those that are publicly supported, supporting organizations that are related to one of these other type of public charities, and then public safety organizations. They test for public safety. So traditional or institutional public charities are your churches, your hospitals, your schools, governmental units. These are charities that don't have to meet any type of support test. All the money, in fact, could come from one place. You could start a church and all the money come from one person. It's not going to be a private foundation, provided it meets the regulations that govern that type of organization. So if you're a school, you've got a faculty, you've got a curriculum, you've got a student body, etc. So there's no additional that's required so long as you meet the regulations. There's an extra schedule that applies on 1023 when you apply. Donative public charities is what most of us are used to when we get asked for money by public charities. They don't provide services for a fee. They take in money and they provide services, and they have to receive at least a third of their total support from the general public and governmental units. If they don't, they have to receive at least 10% under a facts and circumstances test. And you can see some examples there. I don't want to get into the details of this. What I want to look to is the very bottom. So we're talking about a numerator that is public support and a denominator that is total support. And you got to get to a third. And what's excluded from public support in the numerator is contributions in excess of 2% from one source. So let's assume that you've got $1 million over your 5-year base period and you've got to get to a third, so you've got to get to $333,000, but you have to get there in contributions of no more than $20,000 per person. So if you're talking to donors and they're going to be providing significant donations under their will, for example, to one entity, you want to watch out for something called tipping, where you can tip the public charity over into private foundation status. A way around tipping is to utilize a donor advised fund to have it come out in a more regulated pattern. Then you've got service provider or gross receipt public charities. These are supported by the public, not by donations, but by people coming and paying admission. A zoo, an opera, a ballet that charges for their services. Those types of organizations are service provider public charities. They also have to meet some tests. Of course, the tests are different. It's not the at least a third of public support. It's not more than a third comes from your gross investment income and net unrelated business income. And more than a third, not at least a third, but more than a third comes from the general public. How does it come from the general public? By gross receipts. It also has kind of a funny rule, and you see it right under gross receipts. First, we exclude anything from disqualified persons from the top of the fraction. And then second, we count only the public support that is received from an individual that is less than $5,000 or 1% of the total support for the year. And so what that's doing is it's saying you can't be a service provider public charity and get all your support from providing services to 5 people or 5 organizations. If you're going to be a service provider public charity, you got to provide it much more generally to show that you are publicly supported. The third type of public charity, so traditional, publicly supported, which there's 2 types, is a supporting organization. A supporting organization is organized and operated to benefit or perform the functions of another public charity. It can't be controlled by a disqualified person other than foundation managers. Control here means the ability to cause or prevent an action of the supporting organization by aggregating your votes with other disqualified persons. So they can be on the board, but they can't control. They also can't be paid compensation. So you've got to have organizational documents that say this is what we're trying to benefit. You have to list who you're trying to benefit, and now on your 990 you have to say, we're not controlled by donors or related parties, and this is the type of supporting organization we are. You have to be operated to support whatever the supporting organization is supposed to do. Either supporting the beneficiaries of the supported organization or doing something for the supported organization. So let me give you an example of a type 1. This is probably the most common type. Let's say you've got a church and the church wants to create a foundation because it wants to separate its endowment assets from its operating assets for liability protection purposes, for focused governance on endowment, for investment purposes, what have you. And the church appoints the board of the foundation, investment foundation, the endowment foundation. That is going to be a type 1 supporting organization. What you have to think about here is, if the church appoints the board, what's going to happen if the church or the supported organization goes bankrupt? Well, the bankruptcy trustee then appoint the board and say, board, you need to pay over this money. So there are some things that you have to think through when setting up a type 1. A type 2 is operated in connection with, which means an overlap of directors or officers, common control. Not just making payments, but common supervision or control, so they're working in concert with each other. And then type 3 is operated in connection with, and this is the loosest, so it's also subject to the most regulations. You've got various tests, notification, responsiveness, integral part. What I want to say about the responsiveness is, there used to be a rule until December of 2012 that a charitable trust was going to be responsive if it named in its trust document who it was dealing with. That's no longer the case. So you may have to fall into private foundation status. If you fall into private foundation status, now you've got to pay out 5%. If you were restricted on what you paid out to something like only net income, and that's not 5%, you've got to go to court under Cypre, or in Texas 112.054 of the property code, to modify that. I'm going to skip these couple because I want to talk about one final thing, and that is donor advised funds. I got an email this morning that the IRS has recently come out with a study from 2012, and donor advised funds have something like $53 billion right now, even though there's only about 2,000 organizations that hold donor advised funds. Fidelity Charitable has about half of that. So these are big players where people are giving to donor advised funds instead of a foundation. This is where it's owned or controlled by a sponsoring organization like a community foundation. It's tracked with reference to the donor. The donor gets to name a donor advisor, which can be the donor. There are certain exceptions to it, but if you have a donor advised fund, there can't be material restrictions, but these are very useful. They're also very useful in my practice for private foundations. So we'll have private foundations that may terminate into a donor advised fund, but we also have private foundations that will use what I call a sidecar donor advised fund. And this is just a picture of the donor advised fund and the sponsoring organization. But the private foundation's purpose is health. However, it wants to have some one-offs for education. It doesn't want all the educational organizations coming to it. What can it do? It can set up a donor advised fund, and even an anonymous donor advised fund at a community foundation, and do educational payments through that organization if its governing documents are broad enough to allow that. So it does allow for nice one-offs. We've used donor advised funds as an added benefit to individuals on retirement where we want to thank them for their service, but we don't want to pay severance. We'll set up a donor advised fund at the community foundation and allow them to be donor advisor until their death, and then it rolls back to the foundation being the donor advisor. So very useful types of things. Donor advised funds are component funds of the community foundation. That means the community foundation owns the money. That means the giving is from a public charity. So they're very useful if you're trying to satisfy those tests where giving can be from public charity. So I know we've gone through this very fast. Again, I want to say thank you for letting me be here. If you want these slides, you can email me or you can go to my website next week and I'll have them up. If you have any questions, please feel free to grab me. Thanks so much.
Thank you, Mr. Moore. Our second speaker today is Professor Nancy McLaughlin. Professor McLaughlin is the Robert W. Swenson Professor of Law at the University of Utah College of Law, where she teaches a number of courses on estate planning, including a course on conservation easements. Professor McLaughlin graduated from University of Massachusetts Amherst and received her JD from the University of Virginia School of Law. She is a member of the American Law Institute and serves as an advisor to the Restatement of the Law Charitable Nonprofit Organizations Project. Professor McLaughlin is a fellow of the American College of Trust and Estate Council, on which she also serves as the co-chair of the Legal Education Committee. She's a member of the ABA's Real Property Trust and Estate Law section, where she serves in many different capacities. Ladies and gentlemen, please help me welcome Professor Nancy McLaughlin.
So good morning, everybody, and thanks for coming, and thank you for that kind introduction. I also want to thank the Law Journal for inviting me to speak today, and in particular, Professor Beyer and the student editors. They have all been extremely gracious hosts. So I've split my talk this morning into three parts, and I'm going to start with just a very brief primer on conservation easements and the very, very, very generous, as we'll see, income, gift, and estate tax incentives that are offered with regard to their charitable donation. And then I'm going to walk you through part one of the outline that I provided, which explains how to file a tax return if you're claiming a deduction for an easement donation to minimize your risks of audit. And why am I going to do this? Well, some of you may know the IRS has been very aggressively auditing and litigating easement donation transactions over the last decade. Then I'll spend just a few minutes at the end before I open it up for questions to discuss conservation easements just a bit more generally, with a focus on how certain states are responding to the need to make the easement stewardship process over the long term more transparent and accountable to the public. So before I turn to the tax incentives, I want to provide you just a quick description of what a conservation easement is, because some of you may not be familiar with the concept. It's a deed that's conveyed to a government entity or a charitable organization, as we learned a lot about charitable organizations in our last presentation. And generally, the charitable organizations in this context are charitable conservation organizations. Shouldn't come as a surprise, and they are typically referred to as land trusts. And these deeds restrict the development and use of the encumbered land generally in perpetuity, and they do so for the purpose of protecting certain conservation attributes of the land, like open space or wildlife habitat. Now, all 50 states have enacted what are known as conservation easement enabling statutes, and those statutes remove any impediments to the creation and enforcement of conservation easements over the long term. Conservation easements generally held in gross, meaning that they are not held in connection or appurtenant to another parcel of land. And some of you who are taking property law, teach property law, or remember it from law school, you will recall, I'm sure, that in-gross land use restrictions are generally disfavored under the common law. So we needed a statute in every state to make easements enforceable, conservation easements. So as you can see from this slide, there has been a dramatic growth in the use of conservation easements over the last several decades. The National Conservation Easement Database has gathered data on easements encumbering over 23 million acres. But in fact, since it's still in the process of gathering data, it says that it estimates more than 40 million acres throughout the country are now encumbered by easements. That is a huge area. That is more than 50,000 central parks It's more than the total land area of New York, Connecticut, and Vermont combined. It's about 18 times the size of Yellowstone National Park, and it's about 1/4 of the total land area of Texas, and we all know that Texas is huge. So that's a lot of land. Much of the growth in the use of easements has been attributable to the very generous tax incentives that are offered to landowners who donate these instruments as charitable gifts. So there are a total of 4 federal tax incentives provided to landowners who donate easements. The incentives vary depending on whether it's a lifetime donation or a donation made at the landowner or following the landowner's death. If it's a lifetime donation, and if the easement donation satisfies all applicable requirements, then our landowner is going to be entitled to 3 federal tax incentives: a charitable income tax deduction under Section 170H, a federal charitable gift tax deduction, and this gift tax deduction effectively removes the value of the conservation easement from the landowner's estate for estate tax purposes. There's no gift tax paid because of the deduction, and then at the landowner's death, it's only the restricted value of the land that is included in the landowner's estate. And then we have an additional estate tax exclusion under Section 2031C. Upon the landowner's death, the landowner's estate can elect to exclude up to an additional 40% of the value of the land subject to the easement from the landowner's estate for estate tax purposes. There is a cap on that of $500,000. So if the conservation easement is donated after the landowner's death, that's known as a post-mortem donation. There are 2 federal tax incentives. The first is a charitable estate tax deduction, and then we also have the additional estate tax exclusion. Despite the ability to make these post-mortem donations of conservation easements, it's generally not advisable for a landowner to wait to do so. And that is because the landowner would forego the very generous charitable income tax deduction, and there's also no guarantee that a post-mortem donation will actually be made. If the donation isn't mandated in the landowner's estate planning documents, then the personal representative or the trustee generally is not going to have the authority to make the donation. Moreover, there's no guarantee that the landowner's heirs are going to agree to make the donation. There's often significant disagreements among the heirs after a landowner's death with regard to whether to make an easement donation or to sell the property at its highest and best use. So the land, if a landowner doesn't make an easement donation during life and wants to see the land protected, that might not happen. So you need to explain that to the clients. Okay, so with that background, now what I want to do is just walk you quickly through the requirements under 170H, because the requirements for the charitable income tax deduction generally have to be met to be eligible for any of these federal tax incentives. I also want to note that as of December of last year, the enhanced form of the 170H deduction was made permanent. So this means that individual donors of conservation easements are permitted to claim the resulting deduction to the extent of 50% of their adjusted gross income in each year in the year of the donation and the following 15 years. So that's a 16-year period that they can carry forward that deduction. Farmers and ranchers, including C corporations that make qualifying easement donations, they can claim the deduction to the extent of 100% of their AGI over the 16-year period. So farmers and ranchers who make qualifying easement donations can potentially avoid paying any income tax for a 16-year period. There is no other charitable donation that is treated as favorably under the Internal Revenue Code. However, it's not all rosy because the deduction has been subject to abuse, most commonly valuation abuse, and failure to satisfy the requirements of 170H. And as I said, the IRS has been aggressively auditing and litigating these transactions. And part 1 of the outline I provided walks you through developments in this context, and Appendix C shows that since 2005, the courts have issued more than 80 opinions addressing challenges to deductions claimed in the easement context, and that's more case law than in any other charitable donation context. So let's turn to our requirements for the 170H deduction. To be eligible for this deduction, your easement has to be granted in perpetuity to a government entity or charitable organization exclusively for one or more of 4 conservation purposes that are set forth in the code, and the conservation purpose of that easement must be protected in perpetuity. The 4 qualified conservation purposes: preservation of open space, protection of habitat, historic preservation, and protection of land for outdoor recreation or education of the general public. It's only that last conservation purpose that requires public access to the land. So these are the code requirements. We also have Treasury regulations interpreting Section 170H, and they contain a number of additional detailed requirements. Donees of our conservation easements have to have a commitment to protect the conservation purpose and the resources to enforce the restrictions. The easements have to be legally enforceable. That means they generally have to be recorded. The easements must prevent uses that are inconsistent with the conservation purposes of the donation, and the easements must also prevent uses that would injure or destroy any other significant conservation interests on the property. Any mortgages on the subject property, they've got to be subordinated to the easement. Surface and other destructive mining methods have to be prohibited. Baseline documentation establishing the condition of the property at the time of the easement's donation has to be provided to the donee so the donee can properly enforce the easement. The donee has to be given certain notice rights, namely the right to be notified before the property owner exercises any of the reserve rights in the easement deed that may have a destructive impact on the conservation values of the property. Donee must also have the right to reasonable access to the property, so it can ensure that the landowner is complying with the easement, and the donee must have certain enforcement rights, specifically the right to enforce the restrictions by appropriate legal proceedings. So we're not done yet, almost. The donee must also be prohibited from selling or transferring that easement, except to another eligible donee that agrees to continue to enforce the easement. The Treasury Department did, however, recognize that changed conditions could, in some circumstances, make the continued use of certain properties for conservation purposes impossible or impractical, right? Perpetuity is a very long time. So the regulations provide that tax-deductible easements can be extinguished, but only in a judicial proceeding and upon a finding that continuing to use that property for conservation purposes has become impossible or impractical. And if that happens, the holder has to be entitled to a share of proceeds upon extinguishment and has to use those proceeds for similar conservation purposes, basically to replace lost conservation values. Now, some of you might recognize the last 2 bullet points here are basically a restatement of that state law doctrine of cypre that applies to charitable gifts. Well, of course, tax-deductible conservation easements are charitable gifts. They have to be, or they won't be deductible. So it's really not a surprise to see the cypre doctrine incorporated into the Treasury regulations. All right, well, now that we have a basic understanding of the requirements for the deduction, I'm going to turn to part 2 of this outline that I provided you, filing a tax return to minimize your risk of audit. And if you file a tax return in this case, it should contain all the items listed here and in your outline. Because of increased IRS scrutiny, it's very important that each one of these requirements be satisfied. I obviously don't have time this morning to talk about all these in detail. I just want to highlight a few of the more important and interesting points. I do encourage, though, anybody who is representing an easement donor or thinking about donating an easement yourself, please do read through the outline. So let's start with a correctly drafted conservation easement, and this is on page 13 of the outline. It's not always possible, but the best practice here is to file with the tax return the recorded easement. The IRS really wants to see the recorded deed. It's also very important to make sure the appraiser who has appraised the easement has appraised the recorded easement, the easement that was actually placed on the property, and not some earlier draft of the easement that contains different restrictions, which happens surprisingly more often than you might think. On the top of page 14 of the outline, I say that your conservation easement should include extensive recitals, clearly indicating what the conservation values of the property are. That's because you want to make the best case you can in your conservation easement deed about why this property is worthy of permanent protection, because it's going to be an IRS agent reading through the deed in some windowless office, right, in DC or Cincinnati or Ogden, and you want them to take away from your easement deed how wonderful this property is and how important it is that it be protected. Now on page 15, I talk about the issue of reserved rights. This is an extremely important issue. It's of particular interest to the IRS. There were two early cases, Glass and Butler, where the IRS argued unsuccessfully that at full exercise of all reserve rights in the easement deed, the conservation purposes of those easements would not be protected in perpetuity, as is required. Even though the taxpayers won in those cases, those cases should not be viewed as a green light for retaining extensive development and use rights in an easement deed. And that's because in Glass and Butler, the taxpayers hired environmental consultants or experts who testified at trial that the conservation purposes of the easements could still be accomplished even at full exercise of all reserved rights. And importantly, the IRS failed to introduce any evidence to the contrary in those two cases. And after Butler, the IRS informally indicated that it intends to hire its own environmental experts in these cases, and in the Atkinson case, it did just that. Atkinson involved two conservation easements, placed on a golf course located in a gated residential community in North Carolina that is pictured here. And the tax court held that our easement failed to satisfy the habitat protection and the open space protection conservation purposes test. And that was in part because the taxpayers reserved the right to cut down what the tax court referred to as the remnants of the longleaf pine trees on the properties, which you can see pictured here. That was the property's most significant ecological resource. Taxpayers also retained the right to build a variety of structures, restrooms, rain shelters, rest stations, and concession stands on the property. And the taxpayers retained the right to spray the property with pesticides, herbicides, and fungicides. Moreover, unlike in Glass and Butler, in Atkinson, the IRS hired its own environmental expert, who was the director of Duke University's Wetland Center. And the IRS's experts testified at trial that there were no fish or amphibians in any of the ponds on the golf course. There were no natural edges around those ponds where wildlife could take shelter. There were no natural fruits and seeds for foraging on the properties because of all the pesticides. The properties provided no cover for any animals. Migration was deterred by animals because of the residential development ringing the golf course, the human activity, and the frequent watering of the course. And the only birds that the IRS's environmental expert observed on the properties were geese, the Canada geese that you see here, which the owner of the golf course attempted to control, and by that I mean eliminate, through use of a border collie. So Atkinson is a clear signal that the IRS is going to hire its own environmental consultants in these cases to assess the impact of all the reserve rights in an easement deed. And I've included some suggestions in the outline regarding reserve rights and how to make sure that your easement, the conservation purpose of it, will be deemed protected in perpetuity. So the next issue that I want to talk about very quickly is extinguishment. Right? And in the outline, this is on page 21, you can see that extinguishment of a conservation easement requires a judicial proceeding. And the relevant case here is the Carpenter case, which involved conservation easements conveyed with respect to property located in Teller County, Colorado, and the easements authorized the two parties, the landowner and the land trust, to mutually agree to extinguish the easement. And in sustaining the IRS's complete disallowance of the deductions that were claimed, tax court said, to make our position clear, extinguishment by judicial proceedings is mandatory, and the court rejected the taxpayer's argument that the extinguishment regulation contemplates any alternative. Carpenter confirmed an earlier IRS general information letter that told us while state law might provide a means for extinguishing an easement for state law purposes, the requirements of 170H and the regs must nevertheless be satisfied if you want a federal deduction for the easement donation. So next up, on page 24 of your outline, is the issue of swaps, which are prohibited. Swaps involve the removal of some or all of the originally protected land from the conservation easement in exchange for protecting some other land. Swaps obviously involve extinguishment of the easement with regard to the land that is removed from its protection. Now, some taxpayers and land trusts have argued that swaps merely involve the migration of a conservation easement across the landscape and not an extinguishment. And neither the IRS nor the courts have bought that argument. And in Belk, which involved a conservation easement encumbering this golf course, another golf course located in another high-end residential development in North Carolina again, Fourth Circuit held that the donation of the easement, which authorized the landowner and the land trust to agree to swaps, to pull land out of the easement in exchange for encumbering some other land, Fourth Circuit said not eligible for a deduction, and explained regulations offer a single and exceedingly narrow exception to the requirement that a conservation easement impose a perpetual use restrictions, and that is our extinguishment regulation, judicial proceeding, impossibility, and practicality. And the Fourth Circuit said, absent these unexpected and extraordinary circumstances, real property placed under easement has to remain there in perpetuity if you want your deduction. And Belk, as with Carpenter, confirmed an earlier IRS general information letter that explained, except in the very limited situations of a swap that meets those extinguishment requirements, judicial proceeding, impossibility, and practicality, if your easement can be swapped, it's not going to be eligible for a deduction. So we also have the Wachter case, and this is on page 31 of your outline. And in Wachter, tax court held that North Dakota law, which limits the duration of any easement to 99 years, prohibits easements in that state from being granted in perpetuity as is required by 170H. Now, Wachter was a really notable case because it confirmed that a state can render all conservation easements in the state non-deductible because it has passed a law that makes it impossible to satisfy federal perpetuity requirements. Wachter also reiterated the fundamental principle that runs through all of the cases in this area, as well as the IRS guidance, that we look to state law to determine the nature of property rights, but it is federal law that determines the appropriate federal tax treatment of those rights. Now, some of you might be wondering, well, how do you satisfy the federal extinguishment and division of proceeds requirements here in Texas, given that the Conservation Easement Enabling Statute in Texas, which is based on the Uniform Conservation Easement Act, provides that a conservation easement can be modified or terminated in the same manner as other easements? And the answer to that is you need to understand the interaction between federal and state law, and you need to include provisions in your easement deed that comply with the federal extinguishment and other requirements and make it clear that the conservation easement constitutes a charitable gift, and therefore both parties should be bound by the terms of the easement. And in Carpenter, tax court found that the tax-deductible easements in that case constituted restricted charitable gifts, which it defined as contributions conditioned on the use of a gift in accordance with the donor's precise directions and limitations that were set forth in the easement deed. What does that mean? Well, it means that the provisions that you included in an easement deed saying that a judicial proceeding and impossibility and practicality is required to extinguish the easement are going to be binding on both parties under state charitable law, regardless of what the easement enabling statute says. And these concepts are discussed for you, and I've given you some sample provisions starting on page 32 of the outline. So just moving quickly through the remaining items that have to be filed with your tax return to minimize your risk of audit. And this is on page 39, the IRS Form 8283, which is the appraisal summary, which also requires a supplemental statement. If a donated conservation easement is worth more than $5,000, and virtually every easement is worth more than that, then both of these items have to be correctly completed and filed with the tax return. And believe me, the IRS would like nothing better than to be able to deny your deduction in full for your failure to satisfy these requirements. It's a lot less expensive for them to do that than it is to hire environmental experts and go to trial or hire appraisers and challenge your valuation. So be sure you satisfy these requirements. It's really not hard to do, and I've given you samples of completed forms 8283 as well as a supplemental statement in the outline. The third item that you should include with the tax return is the full qualified appraisal. Technically, the taxpayer doesn't need to attach the full qualified appraisal to his or her return unless the easement exceeds $500,000 in value. However, the IRS has indicated informally that it would like to see the full qualified appraisal regardless of value. It's also important to make sure your qualified appraisal satisfies all specific statutory and regulatory requirements. In a few cases, courts have let some of these requirements slide in some donation transactions. In other cases, however, they have denied deductions in full for failure to satisfy some of the qualified appraisal requirements, and still in other cases, even though the appraisal satisfied all of the qualified appraisal requirements, because they were deemed to be sloppy, poorly written, and therefore unpersuasive, the courts denied the deduction in full. So the lesson here is that a donor should not rely on a sloppy or otherwise deficient appraisal. This is an area of particular scrutiny by the IRS, and if you have a bad appraisal, you're likely going to trigger an audit and litigation. So use a good appraiser who has experience in this area. Next, we have our contemporaneous written acknowledgement requirement. Many of you know no deductions allowed for a charitable contribution of $250 or more unless the taxpayer substantiates that contribution with a contemporaneous written acknowledgement received from the donee organization that states whether the donee provided any goods and services, and if so, the value of those goods and services. And as I note on page 50 of your outline in paragraph 5, in some cases where an easement donor failed to obtain a contemporaneous written acknowledgement, the courts held that neither the easement nor any related documents associated with the transaction could qualify as the acknowledgement, and the deduction was completely denied. In other cases, the courts said, well, no, the easement and some of the related documents, that can serve as our acknowledgement, and the deductions were allowed. So the takeaway is, of course, decisions in this context, totally unpredictable. Make sure that you, if you're the donor or if you're the donor's advisor, make sure that your donor obtains that contemporaneous written acknowledgement from the easement donee. And that's true whether your donee is a charitable organization, a land trust, or a government entity. And sometimes government entities can be a little testy about providing contemporaneous written acknowledgements, but you need to make sure you get it. Lastly, we have baseline documentation, or next, I should say, one more after this. To be eligible for a deduction, the donor of an easement, as I mentioned before, has to provide the donee with documentation sufficient to establish the condition of the property at the time of the easement donation. The burden of providing the baseline is on the landowner. However, typically it's the donee organization that prepares the baseline documentation. But Donors and their advisors should ensure that our baselines are extensive and compelling. This is the best opportunity that a donor has as part of the tax filing to persuade the IRS that the property has important conservation values that are worthy of permanent protection. Right? Lots of pictures included in the baseline documentation, and as we know, a picture is worth 1,000 words. Timing of the baseline is also important. It's got to be fully complete at the time the donation is made. Right? You can supplement it over time. Certainly there are going to be changes on the property, but it has to be absolutely clear that your baseline was complete on the date of the donation. And this can sometimes be difficult, right? A lot of these donations are made at the end of the year, in December, when the property is covered with snow, right? So what does that mean? It means that it's very important for the donor and the donee organization to do some advanced planning so they can make sure they have a completed baseline at the time of the donation. Now in 2015, we had our first case in which the tax court held that an easement donor failed to comply with our baseline documentation requirement. And this is the Bosque Canyon Ranch case, which is here, home in Texas, right? I hope I'm pronouncing that correctly. Bosque, yeah? Okay, good. So this involved 2 conservation easements conveyed with regard to land in Bosque County, Texas, to the North American Land Trust, or NALT. Baselines had been prepared by NALT, and the court found that the baseline documentations were not timely, they were not executed properly, and they were unreliable, incomplete, and insufficient to establish the condition of the properties at the time of the easement donation. And the court also noted that NALT's president, quote, failed to clarify these glaring inconsistencies in rambling, incoherent testimony at trial, and that NALT's preparation of the baseline was, quote, slipshod. So baseline documentation, another area of recent focus by the IRS. This is not a difficult requirement to satisfy, but it's very important that you do so, both to avoid having the deduction denied, and also a good baseline is needed to ensure that the donee is going to have the information it needs to properly enforce the conservation easement over its perpetual life. So the last item that needs to be filed with a tax return, if it's applicable, is our correct and timely lender agreement. If there is an outstanding mortgage on the property at the time that an easement is donated, the lender has to agree to subordinate its rights to the rights of the holder of the easement, and that must be done at the time of the easement's donation. If subordination is not obtained at the time of the donation, then the conservation purpose of the easement will not be protected in perpetuity. Why? Because if the landowner defaults on the mortgage and the lender forecloses, the easement is going to be extinguished. Now, in 2 cases discussed in the outline, Mitchell and Minnick, taxpayers argued that their failures to obtain a mortgage subordination agreement should have been forgiven because they had great credit and the chance that they would have defaulted on the mortgage was so remote as to be negligible. Both the 9th and 10th Circuit courts dismissed that argument, and they said, look, mortgage subordination requirement is a bright line requirement. It would be absurd to require the IRS to inquire into the creditworthiness of every individual conservation easement donor. Now, I also want to know that Mr. Minnick, one of the donors, he is a former member of the U.S. House of Representatives from Idaho, and he has sued the law firm that represented him with regard to the easement donation, sued them for malpractice, and I think we can probably expect to see more of these suits as deductions are denied for failure to satisfy specific requirements in 170H and the regs. And on that note, I encourage you to be sure, if you're involved in one of these transactions, to read Part 3 of the outline, because that highlights a number of additional issues that the IRS is currently focused on. But now what I want to do in the remaining time is to shift gears and talk more generally about conservation easements, and in particular about protecting the public interest and investment in these extraordinarily valuable instruments. As we saw in this earlier slide, right, use or growth in the use of easements over the last 3.5 decades has really been extraordinary, right? 40 million acres estimated to be encumbered. This is an illustration of the somewhat similar growth in the use of conservation easements here in Texas, which has an estimated 970,000 acres encumbered. And this is a very low estimate because, as I mentioned, this is from the National Conservation Easement Database, but they are still in the process of gathering data. And what we're seeing across the country is the start of increasing pressures to modify and extinguish these perpetual instruments. And this, of course, raises the question of who is going to ensure the protection of the public interest and investment in these instruments over the long term. We all, as members of the public, through these very generous federal tax incentives and very generous easement purchase programs, have now invested billions in these conservation easements. So what I want to do is just briefly describe to you what has been done in the 3 states that have taken the lead in this area, Maine, Rhode Island, and New Hampshire, and I also want to highlight what recently happened in Vermont as a cautionary tale. So let's start with Maine. Maine has close to 2.5 million acres encumbered by conservation easement. That is roughly 10% of the state of Maine. And in 2007, the Maine Attorney General's Office, in collaboration with the Maine Land Trust community, worked with the state legislature to revise the Maine Conservation Easement Enabling Statute. And now that revised statute provides that conservation easements can be terminated in Maine or modified in manners that materially detract from the conservation values intended for protection only in a judicial proceeding in an action in which the AG has been made a party to protect the public interest. And if there's any increase in the value of the land as a result of an amendment or a termination, that increase has to be paid over by the landowner to the donee, the holder of the easement, to be used to replace lost conservation values. Revised statute in Maine also requires that all holders of conservation easements in the state register the easements with the state and update that registration annually. And the Attorney General's Office provides land trusts and government entities in the state with guidance regarding conservation easement amendments, right? When is a court approval required and when is it not required? And a study was done in 2011, 4 years after this was enacted, and the reforms, by all counts, appear to have been very successful and are strongly supported by the Maine Land Trust community. Next, we have Rhode Island. It adopted legislation similar to Maine's requiring court approval to terminate an easement, and the Rhode Island statute also confirms the AG's inherent authority to bring an action in court to enforce the public interest in conservation easements. The Rhode Island Attorney General actually recently objected to a town's attempt to terminate a conservation easement or a perpetual easement that encumbers this land known as the monastery land. Town wanted to use 20 of the encumbered acres to develop a new public safety complex with new offices for police and emergency services. There was considerable public opposition to the termination of the easement, and the woman who spearheaded that effort is pictured here on the stairs of the property. Well, the Rhode Island Attorney General issued an advisory opinion to the town explaining that the conservation easement could be terminated only with court approval. So facing an uphill battle against public outcry, the Attorney General, and having to go to court to terminate the easement, the town decided that it would find another site for its complex, a site that had not been permanently protected because of its conservation values. Now, also like the Maine AG's office, the Rhode Island AG's office has been providing land trusts and government entities with guidance regarding amendments to easements in that state. So moving on to New Hampshire, in 2010, the New Hampshire AG's office worked with the New Hampshire Land Trust community to develop a set of guidelines for the amendment and termination of conservation easements in New Hampshire. And I've given you a link here on the slide to those guidelines. The AG's office in New Hampshire has since helped land trusts resolve a number of tricky amendment issues, has participated in at least one judicial proceeding involving a partial termination of a conservation easement, termination of the easement with respect to a very small part of the property. And the folks from the New Hampshire conservation community report that they like this process and working with the AG's office because it legitimizes decisions that are made in difficult amendment and termination situations, right? The decisions are not made behind closed doors. They are made with the participation of the AG who represents the public interest. And they've also indicated that it discourages landowners from seeking inappropriate amendments and terminations. A number of the folks in New Hampshire have reported that they've had landowners call them up and request inappropriate amendments, swaps, terminations, and all they have to do is mention this process and the need to consult with the AG, and those folks are quickly sent on their way. So we also have a cautionary tale from Vermont. In Vermont, a statewide land trust tried for several years to get legislation passed that would have authorized a 5-member politically appointed panel to approve the amendment and swapping or other termination of conservation easements if the panel deemed it to be in the very broadly defined public conservation interest. Having built up a large inventory of easements, the land trust apparently decided that it needed more flexibility to modify, swap, and terminate the easements. Well, the proposed legislation was extraordinarily controversial, and it was criticized on a variety of grounds, and just in the interest of full disclosure, I was among the critics of this proposed legislation. And folks were upset that the legislation would have allowed land trusts with the approval of a 5-person panel to basically swap or terminate what everyone thought were perpetual conservation easements that would protect in perpetuity certain parcels that had significance to communities and particular landowners. It was also pointed out that the legislation would have rendered conservation easements in Vermont ineligible for federal tax incentives. Why? Because it would have permitted easements to be extinguished outside of the judicial proceeding that I talked about. Had the legislation passed, Vermont would have joined North Dakota as only the 2nd state in the country to deny its landowners of the ability to take advantage of the federal tax incentives for easement donations. So the proposed legislation created serious public relations problem for the land trust that had supported it, and in response to widespread public outcry and pressure, the land trust eventually withdrew the proposal, and you can read about the controversy at the link that I provided here on the slide. So I want to end just by noting that attorneys general are increasingly recognizing their role and responsibility for protecting the public interest and investment in conservation easements. In addition to Maine, New Hampshire, and Rhode Island, we have seen attorneys general in Maryland, Wyoming, Connecticut, Virginia, and Pennsylvania step up and defend conservation easements on behalf of the public. And I hope and expect that the Attorney General in Texas would be similarly committed to protecting the public interest in these instruments. And in fact, I'm happy to provide you with the name and contact information with someone in the Texas AG's office who I know is familiar with these issues. So on that note, I will stop. I don't know if we have time for questions or it is time for the break. What would you like? Okay, if anybody has any questions, I'm more than happy to field them. Or maybe everybody needs a break. Oh, sorry. Sure. I can give you some suggestions that I think that you should include in your statute. I mean, it's probably a little bit outdated at this point. The reforms in the other states, I think, are definitely steps in the right direction. And in fact, we just had a Virginia Supreme Court case, the first case from a high court in the country addressing whether conservation easements should be interpreted in favor of free use of land the rule that applies to restrictive covenants or in favor of their conservation purposes. And Virginia has the same statute that Texas has, and the court said, the Virginia Supreme Court said, conservation easements are interpreted in favor of free use of land, which is a very bad result because it'll make conservation easements very difficult to enforce over time. So what people need to do now is make sure they include a provision in their easement deed saying the two parties agree that this conservation easement will be interpreted in favor of carrying out its purposes regardless of any general rule of construction in the state. But there are some states that include that in their easement enabling statutes. So that is definitely one provision that I would say you should revise the Texas statute and include that so it's not an issue. So if people leave it out of their easement deed, it still won't be a problem. But there are other things that, and we can talk about that. Okay, well, thank you very much. And if anybody has any questions, I'll be, during the break, out in the area there. Thanks. Oh, you need this.
Okay, as we said, we'll go ahead and take a quick 10-minute break. We'll start back here at 10:22, so I'll actually give you all the full 10 minutes to use the restroom and so forth. Don't forget about the raffles that are at the booths out there, so we'll see you back in a few minutes.